Senator Slama has been unable to depose Mr. Herbster to date, despite the duly noticed deposition. So frankly, we have not been able to test the veracity of anything included in this affidavit. So we would ask that it not be accepted unless or until Mr. Herbster is willing to sit and be cross-examined over whether he indeed has personal knowledge over what, for instance, Mr. Lopez or Ms. Slama may or may not know.
I mean, the reality is, everyone knew that he was in the last week of a campaign, and the way campaigns operate, people know that a candidate for the Republican governorship is not going to be available to sit for an all-day deposition.
We're past that, right?
Exactly, Your Honor.
We're past that. Can he be deposed now?
Pardon?
Can he be deposed now?
Your Honor, what I do think is appropriate is to get the pleadings in order in terms of knowing the complaint, knowing the answer, so that the pleadings are framed and we can proceed forward with the deposition. I don't think this case should be tried in the media. I don't think counsel should be issuing press releases to the press with copies of motions that haven't even been served on opposing counsel.
A through G are just 7 of the separate statements made by the plaintiff and his agents in this matter, to which Senator Slama and her agents were frankly required under Rule 6.3 to respond to.
But note, I've read all the pleadings. Since April 22nd, 2022, just the pleadings, not the requests for expanded media coverage, other matters, 251 pages. And most of them appear to be press releases captioned as court filings, and many of them have ended up as press releases or in the press. It's hard to navigate this corner of the world without running across those. The lawyers that practice in front of me 99.99% of the time can get together and act like professionals and negotiate things. And I don't think that you are unable to do so, any of you. And if there's something that you can't, I'm here. All right, we're back on the record. Herbster v. Slama, all counsels present. We were off the record on defendant's motion to compel, which also encompassed the plaintiff's objections to the issuance of subpoenas. Again, we had a meet and confer for approximately an hour.
Yes, sir.
So, counsel, were we able to resolve anything? Mr. Lopez first. Anything?
Your Honor, we've made substantial progress on the items that are under objection in the various subpoenas. What we would recommend, and we're going to be trading some language back and forth in the coming days to hopefully bring those conversations and conceptual agreements into execution and potentially dispose of the issue for the court.